Thumbs up, like, share, and subscribe. Thumbs up, like, share, and subscribe. How's everybody? How's everybody? Mm-hmm. Thumbs up, thumbs up. Like, share, and subscribe, family. Thumbs up. Give me a thumbs up. We're live here. And welcome to the Lawyer Henderson Podcast Show. I'm going to give you all to come in on the room here because we have some important. Um, this is very important for those people who have ever went to federal court. Okay, if you've ever been in federal court like I have, come on in the room. We'll talk about what happened and what the Wall Street Journal have found about these crooked ass federal judges. Come on in. Mm-hmm. See, I stay on. See, I don't care how powerful you are. I go after you on my blog. See, that's why Screw Two has a problem with me. My video that I did, I think it was on R. Kelly, I think it was, and then I did one on Dr. Fauci and all that. Those videos, one of them got removed, and the one I did on R. Kelly at the end, where I talk about the police and how they're killing our people for their organs and stuff. That at the end of that R. Kelly, um, uh, video essay that I did, that got shortened to 30 something minutes. So that letting y'all know that the new voices of black media, man, shoot, man, people are listening to us. People are listening to us, and one of the things about the new voices of black media is that, man, nobody wants to listen to the old dead black media. They don't want to listen to the white media because they don't basically tell the truth. They got an agenda. They got an agenda. You got Hollywood where black men wearing all these dresses and stuff. Come on in the room. Come on in the room. hmm Let's talk about it. See, see, when you're not afraid to basically talk about the issues, then white supremacy, they get upset with you. We got the white media, they basically don't know what to do. Um, and so yeah, that's what's going on. But come on in the room with us. Today we're talking about 131 federal judges broke the law by hearing cases where they have financial interests. Isn't that a bitch? You see, I told you this is how these federal judges operate. They'll take a look at it, like, for instance, they'll take a look at a case law or a case, and they'll try to find who is the weaker of the two. You understand? And after they finish find who is the weaker of the two, come on and thumbs up, like, share, and subscribe. Then they'll rule in favor. They'll find ways to rule in favor of that particular person. Those are that corporation, I should say. That's a violation against the law. So 131 federal judges broke the law by hearing cases where they had financial interests. More than 130 federal judges have violated U.S. law and judicial ethics by overseeing court cases involving companies in which they or their family own stock. A Wall Street Journal investigation found that judges have improperly failed to disqualify themselves from 685 court cases around the nation since 2010. The jurists were appointed by nearly every president from Lincoln, Lyndon Johnson to Donald Trump. About two-thirds of federal district judges disclose holdings of individual stocks, and nearly one of every five who did heard at least one case involving those stocks. Alerted to the violation by the Journal, 57 of the judges have directed court clerks to notify parties in 329 lawsuits that they should have recused themselves. That means new judges might be assigned potentially unpending rulings. When judges participate in such cases, about two-thirds of their rulings or motions that were contested came down in favor of their or of their family financial interests. In New York, Judge Edgardo Romes handled a suit between an ExxonMobil corporation until the TIG insurance company over a pollution claim while owning between 15,001 and 50,000 of Exxon stock. According to the financial disclosure form, he accepted an arbitration panel's opinion that TIG should pay Exxon 25 million and added a 8 million of interest in a tab. In Colorado, Judge Louis Backup oversaw a case involving Comcast. Now let's just talk about the thumbs up family of the ExxonMobil, what this Eldorado Ramos did. Now, see, they're not talking about in Congress about impeaching none of these judges. They're already talking about a federal law legislation. No, you've already broke the law, and there's already a law that tells you you shouldn't do this. You should recuse yourself. And this is my problem with the federal court system because these people are appointed for life. They can only be removed from impeachment just like the president. I have a problem with that. I have a real serious problem with that because these folks will take a case like Thrash did in my case in Henderson versus U.S. Securities. They will take a case and they will look at who is the weaker of the person and then they'll rule in summary judgment for them even though the evidence are there. You understand? So like in Comcast, and that's the reason why I advocate for jury trials. You know, these judges would have really had something to go on if they would have said, okay, well, these cases, we will give jury trials. But most of the time, they're so damn lazy and they try to break the law and try to end these cases in summary judgments, like Thomas Thrash, who used to be the chief judge of Georgia, did. And we're going to get to the new chief judge, Timothy Batten, here in a minute, who should also step down because his whole, what they call morality and ability to be a chief judge is now at stake. And he's been appointed by Thrash, which is another issue. And then the problem with this, and I'll get into it, let's go ahead, let's go on. No phone calls today. We are basically live. Chat now with me in the chat room. Ford Motor Company. In a trademark dispute while her husband held stock in an automaker after she and others on the three-judge appellate panel heard arguments, but before they ruled, her husband's financial advisor bought 2 chunks of Ford stock, each value at up to $15,000 for his retirement account, according to her disclosure form. Thumbs up, like, share, and subscribe. Same thing that the politicians do. The judges do the same damn thing. They go out and they buy and purchase into stocks where they know that they're going to rule in favor of whoever the person who is going to get the ruling. Edgardo Romance, Louis Bacot, and Julia Smith Gibbons, the hundred of recusal violations found that journal breach a bedrock principle of American jurisprudence. No one should be a judge of his or her own cause. Congress first laid out the principle in 1792 to guarantee litigants an impartial judge and reassure the public that courts could be trusted. They came. And I'm going to tell you now, courts cannot be trusted at all, especially the federal ones, because they're not basically, you cannot, recall them. Judge Romas, who oversaw the Exxon cases, was unaware of his violations, said an official of the New York federal court, because his recusal list, a tally judges keep of parties they should have in their courtrooms, listed only parent ExxonMobil Corp. That's not an excuse. Like y'all tell us, there should be no ignorance to the law, and not the unit whose name includes the additional word oil. The official said that the court conflict screening software relied on exact matches. The unit has informed the court at the outset of the case that it was a subsidiary of ExxonMobil, so Judge Ramos could evaluate possible disqualifications or recusal, a court filing shows. After the Journal contacted Judge Ramos, who was named to the court by former President Barack Obama. The court clerk notified the parties of the stock holding. TIG attorneys asked the court to set aside his ruling and send the case to a new judge um, because of the insufficient appearance or a lack of partiality. Exxon opposed assigning new judge, calling that a manifest unfairness, gross inefficiency, and waste of judicial resources. An appellate court has put a hearing on hold until the district court decides what to do. In the Comcast, a Colorado couple asked Judge Babcock to issue an order blocking Comcast from assessing their property and install fiber optic cable. Representing themselves in court, Andrew O'Connor and Mary Henry accused Comcast worker of bullying them, scaring their 10-year-old daughter, and injuring their dog. Uh, Einstein allegations the company denied. Judge Babcock, who was appointed to the court by former President Ronald Reagan, ruled the couple has continually blocked Comcast access to the easement. He sent the case back to the state court as Comcast wanted. I dropped the ball, Judge Babcock said when asked about the recusal violations. He blamed flawed internal procedures. Thank you for helping me to stay on my toes in the way I supposed to, he said. A Comcast spokesman declined to comment. No, he just got caught. See, now he wants to apologize when he get caught. Yeah, no, you just got caught. Mr. O'Connor, who settled his case in state court, said if you are a federal judge, you should not be holding individual stocks. Judge Gibson from the Ford trademark case, appointed to the appeals court by former President George W. Bush, she said, has mistakenly believed holding in her husband's retirement account didn't require her recusal. She later directed the clerk of the 6th U.S. Circuit Court of Appeals to notify the parties of the violation and said that her husband has since told his financial advisors not to buy individual stocks. I regret my misunderstanding, but I assure you it was an honest one, she said. A spokesman for Ford said a fair and impartial judiciary is critical to the integrity of our legal system. In this case, a violation of Ford's trademarks was clear. I dropped the ball. Thank you for helping me to stay on my toes that way I supposed to. No, you just got caught. Thumbs up, like, share, and subscribe. Nothing bars judges from owning stocks, but federal law since 1974 has prohibited judges from hearing cases that involve a party in which their spouses, or their minor children have a legal or edible interest, however small. That law in the Judicial Conference of the U.S., which in federal courts policy-making body requires judges to avoid even the appearance of conflict. Although most lawsuits don't directly affect the company's price, the Supreme Court in 1988 said the law purpose is to promote conflict in judiciary. Now, right there, that's what I had a problem with Thrash on, Thomas Thrash, of the former Chief Judge of Georgia. When it says that the law and Judicial Conference of the U.S., which is a federal court policymaking body, requires judges to avoid even the appearance of a conflict, although most lawsuits don't directly affect companies' stock price, the Supreme Court 1988 said the law purpose is to promote confidence in the judiciary. Thrash has a lot of cases that he oversaw, and I don't know if he's one of the 131 federal judges. He should be. I'm going to contact the Wall Street judges to see. But when it says that the law and judicial conference in U.S., which federal court policymakers body requires judges to avoid even the appearance of a conflict. See, with him, he would basically rule on his own. When somebody, since 2005, people have said that, hey, Judge Thrash, you have a a ability. You have a ability. I mean, a disability. I'm sorry. You have a disability that make it appears of your biasness in these cases. So the law says that it is an appearance of a conflict. He hate pro se plaintiffs. So having a disability of hating pro se plaintiffs, you should step aside these court cases where pro se plaintiffs have basically their cases in your court, and he rules on his own judgment against um, those those cases where, or those petitions where he is basically is sent asked, can you recuse yourself? And he doesn't do it. And I'm going to get to him as far as the Comcast data breach here in just a moment, where there was a conflict of interest, or there was an appearance of a conflict, and he still presided over the Comcast settlement here, which I thought was very, very, very strange of him doing so, considering the fact that he is friends with the former governor of Georgia, Roy Barnes. Roy Barnes, his law firm is all of a sudden is one of the law firms that was participating in the Equifax data breach. But I'll get to that in a minute if I have time. So that's why I want to read that two or three times. I want people to understand in federal court, even if there's an appearance of conflict, okay, then the judges have to set aside themselves, or I'm sorry, recuse themselves, and they have to give the case to another judge. And these cases, along with other types of things that show impropriety issues, these judges did not do that. When people told Thrash in Georgia federal court, dude, you are a biased judge against pro se plaintiffs, you should have recused yourself, Judge Thrash, in these cases. And so the Wall Street Journal says 131 judges. We have some appellate judges that's also involved in this stuff as well. Okay, and so now it goes on to say that conflict of interest rules are common for state and federal employees, as well as for lawyers, journalists, and corporate executives. U.S. government workers may not participate personally and substantially in matters in which they have a financial interest. The Journal Review Financial Disclosure Form filed annually for 2010 through 2018 by roughly 700 federal judges who reported holding individual stocks of large corporations, and then compared those holding to tens of thousands of court documents in civil cases. The same conflict rule applied to criminal cases, but large companies are rarely charged, and the journal found no instances of judges holding shares of corporate criminal defendants in their courts. It found that 129 federal district judges and two federal appellate judges had at least one case in which a stock they or their family owned was a plaintiff or a defendant. Judges' stock holding exceeded 15,000 and 173 cases and $50,000 in 21 of those cases, although under the law, the amount doesn't matter. The journal found 61 judges of their families not only holding stocks in the companies that were plaintiffs or defendants and the judge court, but also traded the stocks during cases. You see how corrupt and abusive of power that they are? That's the reason why they shouldn't have appointments for life. You see? Judges offered a variety of explanations for their violations. Some blamed court clerks, some said their recusal list had misspellings that foiled the conflict screening software. Some pointed to trades that resulted in losses. Others said they had only nominal roles, such as confirming settlements or transferring cases to other courts though there is no legal exemption for such work. Now, here's the thing: it doesn't matter. The law doesn't say, "Hey, maybe if it doesn't exceed $100, I'll get, you know, I can basically still preside at the case." That's not what the law says. The law says even if you had $5 inside the stock, you are supposed to recuse yourself. And these judges not only dropped the ball, but they should resign. They should be impeached by Congress. But see, they're not going to do that because the politicians does the same thing. And this is what we're talking about: high crimes and misdemeanors and the corruption of the judiciary. Now let's go on to say, because we're going to get to the point here in just a moment. The Ethics Code for federal judges require recusal when a judge has a financial conflict, regardless of the substance of the judge's actual involvement in the case. The Judicial Conference Committee of Codes of Conduct wrote in a letter to a judge this month. Some blame court clerks. Some of their recusals list as misspelling, some pointing to trades that resulted in losses. In response to the journal's finding, the Administrative Office of the U.S. Court said the Wall Street Journal's report on instances where conflict inadvertently were not identified before a case was resolved of transfer is troubling. The Administrative Office is carefully reviewing the matter. Nah, it's too late, man. Just resign, man. Y'all are corrupt, man. Y'all were voting on y'all were ruling in favors of people of the companies where y'all had holding in, and then on top of that, y'all was getting money from the stocks in the back end after y'all made y'all little rulings in favor of whoever. Y'all just corrupt, man. It's just sickening how corrupt this country is with politicians, judges, all of these folks, man. It just shows you there's no integrity in the political game. There's no integrity in the judicial system. We all know that. Sending all these black men to prison and jail, the white man get away with a lot of crimes, and now we want to change the law instead of even removing them or putting them in jail for what they've done. It's just amazing. But it goes on to say here, they always talk about they're reviewing the matter. Yeah, y'all not gonna do anything. Stop playing because y'all got the complexion for the protection. It goes on to say that it said the federal judiciary takes very seriously its obligations to preclude any financial conflict of interest and has taken steps such as conflict screening software and ethics training to prevent violations. We have in place numbers of safeguards and are looking for ways to improve, the office said. See, when white people violate the law, it's always, well, we're going to take a look at it. We're going to improve this. We're going to do this. We're going to try to make sure that everything is corrected. And we basically took actions immediately when we found out that we violated the law. Yeah, whatever. See, and this is what we're talking about. Okay? But see, when the black man breaks the law, they want to throw us under the jail. And that's the reason why R. Kelly should get a new trial. We're going to be talking about R. Kelly again, how they broke the law in his case, and how the federal government basically broke the law in his case and adding in stuff, letting people lie under oath. We're going to be talking about that in the next video that we're going to be doing here. Because ScrewTube had taken a lot of it. They had like basically shortened the video where we were talking about a lot of things that they was doing, the government was doing in R. Kelly's case. Thumbs up, like, share, and subscribe, family. So yeah, it goes on to say, let's see. Yeah. Chief Judge John Roberts, who head the federal judiciary, didn't respond to requests for comment. The nation's roughly 600 full-time federal trial judges, supplemented by about 460 semi-retired jurists, called senior judges, wield enormous powers, holding lifetime appointments. They preside over hundreds of thousands of civil and criminal cases each year in 94 court districts. They have sought to nut control over all elements of their courtrooms, from pretrial process and trials to criminal pleas, judgments, and sentencing. Judges have wide latitude for the fact finding and evidentiary ruling, most of which can be overturned only for abuse of discretion, a high hurdle. Violation of the 1974 law almost never become public. Judges' financial disclosures aren't online or cumbersome to request. Sometimes it takes years to access. Judges are informed if anyone requests to see their disclosures, creating a disincentive by lawyers who might fear annoying judges in whose courtrooms they frequently appear. Judges rarely make public the list of companies on whose cases they should work. When judges disqualify themselves from cases, they typically don't disclose details. No judges in modern time have been removed from the federal bench solely for having a financial interest in a plaintiff or defendant that appeared in their courtroom. I just blew it. I regret any questions that I've created an appearance of impropriety or a conflict of interest. This is Judge Timothy Batten, senior, when he was notified of the violation. And speaking of him, he is the chief judge of Georgia now. Let's get to him. But before we get to him, we want to talk about. Hold on. Thumbs up, like, share, and subscribe. He got appointed by Thrash, which was a former chief judge. Okay, so Judge Batten himself owns shares in J.P. Morgan Chase. Goes on to say, Judge Batten himself owns shares of J.B. Morgan Chase and Company. While he heard 11 lawsuits involving the bank, most of which ended in bank's favor, the journal analyst shows. I am mortified, Judge Batten said in a phone interview when notified about his violations, which occurred in 2010 and 2011 before he joins the Code of Conduct Committee in 2019. I had no idea that I had interest in any of these companies and what was most modest retirement accounts managed by a broker. I just blew it. I regret any questions that I created or appearance of impropriety or a conflict of interest, he said. Now, he knew that he had interest in JP Morgan. He had to have known. This man is a liar. And this is who Thrash appoints to be the new chief judge. And let me tell you something about these judges in federal court. They will lie, they will manipulate your case file. They basically will do everything if it means to, if they'll first, like I said earlier, they'll look at which case or which corporation that they show to have a weakness. And then they'll rule in the other person's favor, not only because of personal interest, but they believe that there would be no real backlash, in sense of people calling them out. Now, like I said, before Batten, Judge Batten, there was Chief Judge Thomas Thrash. And what Thrash would do is that he has a lot of problems with conflict of interest against pro se plaintiffs, but he never ever have recused himself in those situations. Okay? So what he'll do is he'll look at a case and he'll go, I'm gonna toss this out, I'm gonna toss that out, I'm gonna toss this claim out. And you're looking like, what the hell are you doing, dude? Why are you tossing my claims out? Well, the jury may not rule against you. Well, how the hell, rule in your favor. And you're sitting there like, how the hell do you know what the jury is going to do? See, that's what these federal court judges do because they are too lazy to give the appropriate people who needs to go to trial by a jury. Like pro se plaintiffs, they need to go to trial by a jury. They don't need a judge talking about, well, we're going to end this on summary judgment because here's the thing. We do not get to go to the Supreme Court. The Supreme Court basically do not want pro se plaintiffs there, right? So since the Supreme Court don't want pro se plaintiffs cases, it is only fair that they basically give you a trial by jury as a pro se plaintiff, because that basically really sets aside, number one, it shows you that there's impartiality in the judiciary, and number two, it shows you that even if you think that a pro se plaintiff does not have a case, you should still say, okay, y'all go before a jury of your peers. But what Thrash will do, he'll sit and look at your case, and he'll toss out all of your claims, and then before you know it, you don't have a lot of things to work with, because he done threw out all the claims and stuff. And that's what they've been doing in Georgia federal court. There's a lot of judges in Georgia federal courts who have recused themselves based upon, they are should have recused themselves based upon it, or should have recused themselves based upon the appearance of a conflict of interest. That is also the law. Okay, that is also law. Hold on. If you got the appearance of that you cannot be impartial, then that's a disability. That means that you're supposed to set aside yourself or recuse yourself and then give it to another judge. Okay? It goes on to say about Judge Batten, who's the current chief judge of Georgia here. He says Judge Batten, appointed by former President George W. Bush, oh God, said he stopped investing in individual stocks in 2012 and moved his portfolio to mutual funds, in which don't require recusal, and has since closed the accounts. That's not an excuse. The journal analyzed cases to determine whether judges may rule in contested motion, such as those seeking dismissal of summary judgment. Judges ruled on contested motions in 21% of their nearly 700 cases in question. Those rulings favored the judge's financial interest in 94 cases, went against the judge's interest in 27 cases, and had mixed outcomes in 24 cases. Already, several parties on the losing side of their rulings have petitioned for a new judge to hear their cases after they were alerted to the violations identified by the journal. Several judges misunderstood the law, initially saying that they didn't have to recuse themselves because their shares were held in an account run by a money manager. Now, how the hell several judges misunderstood the law? But wait a minute, you're supposed to be there interpreting law. How can you misunderstand the law? Ignorant has no excuse now. You shouldn't be ignorant to the law now. Isn't that what y'all tell us in federal court? You shouldn't be ignorant towards the law. That's no excuse. Oh yeah, there's no excuse for you to be ignorant toward the law if you're sitting in these high places as a judge. You're supposed to be interpreting the law. Several judges misunderstood the law. What you mean you misunderstood the law? And you're supposed to be sitting there interpreting the law. That shows you that you basically have a disability right there. When you mention that several judges misunderstood the law, what the hell? And these are the types of people, and we know why you already sitting in these judgeships anyway. Again, you got the complexion for the protection. But anyway, it goes on to say the ban on holding even in a single share of companies while presiding in the cases involved the firm means judges must be vigilant. You know, they must be vigilant. This is going to mess me up here. The 1974 law requires judges to inform themselves about their own financial interests and make a reasonable efforts to do the same for their spouses and any minor children. The Judicial Conference of the U.S. required courts to use conflict checking software to help identify cases where judges should bow out. Okay. Judge Janice Sammartino of California traded in stocks of Bank of American Corp, um, CBS Health Corp, what's that? Deutsche Bank AG, Hartford Financial Service Group, HSBC Holdings. Now he or she, whoever, went and invested in Pfizer, Public Storage, Wells Fargo and Company, and Microsoft Corporation, while hearing 18 lawsuits involving one or more of those companies. The journal found in all she had heard 54 cases involving companies held in her family trust. In the Microsoft case, a Chicago man alleged the software giant violated the Telephone Consumer Protection Act by sending a unsolicited text about its Xbox gaming console to his mobile phone. He filed a suit in 2011. One of Judge Sammartino's family trust bought Microsoft stocks between 2012 and added three purchases in 2013. Okay. The plaintiff's lawyer sought in 2013 to turn the case into a class action involving 91,708 people who alleged received text messages. Microsoft said that it had received permission to send the text, but the records confirming that it had been destroyed. Had a class been approved, the case could potentially have cost Microsoft more than $45 million, according to the court filings by the plaintiffs. Judge Sammartino denied the class action motion as well as Microsoft's motion to dismiss the case. She ruled that the law permitted the plaintiffs to seek damages of $500 for one alleged violation, potentially triple. He appealed but settled before the appealed. I'm sorry. He appealed but settled before the appeal was heard. A spokesman for Microsoft declined to comment. One of the plaintiff's lawyers also declined to comment. Judge Sammartino, an appointee of former President George W. Bush, initially referred questions from the journal to William Craycraft, a spokesman for the Ninth U.S. Circuit Courts of Appeals. She asked me to let you know her stocks are in a management account, so she's not seeing as how there could be a conflict. Ms. Craycraft said. She is not inclined to disclose her private business with you since it is in all management accounts, and she thinks that's sufficient. No. Wait a minute. You are a public official. You are to disclose everything. Your tax records, where you have publicly traded stocks in. That's the 1974 rule. An opinion by the Judicial Conference Committee Code of Conduct in 2013 confirmed that judges must bow out of cases involving stocks they own in accounts run by money managers. Judge Sammartino later informed the court clerk's office of the conflicts, and the officer filed a letter notifying parties to the Microsoft cases and other cases with violations identified by the journal. Judge Sammartino was not aware of the financial interest at the time the case was pending. The letter said the matter was brought to her attention after the deposition of the case. Thus, financial interests neither affect nor impacted her decision in the case. However, her financial interests would have required recusal. Before the journal contacted Judge Sammartino about her recusal violation, she disqualified herself in at least 10 other cases involving companies whose stock were listed on her disclosure form. Of a review her cases shows. See, when they are called out, they're basically now try to, they'll try to now try to clean up their little act when they're called out. See, this is the problem with federal judges and politicians. All of their disclosures as far as where they have stocks in is really a violation of the 1974 Act, a law that's supposed to tell them you're supposed to disclose to the public if you have a public interest in anything. And then what they'll do is they'll basically know that they have a public interest, but since it is a private account managed by either them or their money manager or their family members, or they might put it in the trust account to somebody else's account, and they go ahead and preside over those cases, and then still there's a conflict of interest, and they think nobody knows about it, so they'll go ahead and continue to be on the case. And that's how Thomas Thrash does it. And it goes on to talk about a lot of other judges who's engaged in this, and I'm not going to bore you with that. You've heard enough. But the bottom line is that these 131 federal judges and over almost, what was it, 650 court cases. You had 131 30 judges, or they said 131 in the other articles, but 130, I'll take their word for it here because this is the Wall Street Journal. 130 federal judges engaged in 685 cases, and this has to involve a lot of people, thousands of people. And it's not just only a financial interest. There are judges, excuse me, it's not just financial interest. They need to start also investigating federal judges on the fact that a lot of them have a disability when it comes to presiding over cases where a pro se plaintiff is involved, in the fact that the pro se plaintiff is not going to get a fair trial because of a judge who don't like them in the courts, who's frustrated about their situations in the court. And Thrash is one of those judges. We told you here that when you basically have judges violating the law and they're talking about, well, I didn't know that my case, I was supposed to recuse myself. No, 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 no. You're interpreting the law. You shouldn't be ignorant to the law, and that's no excuse of you breaking the law. And like I said, there should be no minimum. Doesn't matter if you have $10 in the account of a stock, or $100 or $1 million or whatever. You're supposed to reaccuse yourself because that's what the law says. Okay? And so, therefore, when these high crimes and misdemeanors happen under federal law, Congress, the law said, is supposed to take action. The fact of the matter is that what they're trying to do now is they're trying to correct the problem by notifying the parties involved. But it's already the fact that you've broke the law, so now, even if you gave it to another judge, they're going to basically help you familiarize with the case. You're going to have a conversation with them on the case. You're going to look back at the case, and you're going to try to find ways to, again, make sure that the ruling is in the favor. But even though I think most of them are going to settle now, especially Microsoft. Microsoft have been getting away with crimes for years. And they have been getting away with breaches against black folks as well, like Facebook and Microsoft and other social media. Black people have a class lawsuit against them for millions of dollars, in which we have not pursued yet. And again, on YouTube as well. We have a class action as us in the black media. Right now, we have a class action lawsuit that we should be trying against YouTube for engaging and interrupting our channels and trying to basically say that we cannot call out the pharmaceutical companies or Dr. Fauci and this vaccine. These are violations of freedom of speech. These are not only violations of freedom of speech, but these are violations that YouTube and their CEO knows that they're encroaching upon civil liberties. The judges goes on to make more excuses for themselves by claiming that there was a error in the clerk's office, which is another lie. Which is another lie. Okay? And so what I'm saying is that these judges should step down. Because now, going to their court, and then you have politicians saying, and like I said, politicians do the same thing. Politicians will go in there. They know that they have stock ownership in a company, But what they'll do, they'll go inside. They'll basically look at their portfolio and who they have stock in, and then when they pass like millions of dollars of packaging in Congress, then the politicians will go and see, well, who is going to get all the money inside these companies and corporations. What they'll do is they'll hurry up and invest in those companies. There's a book that talked about this. So, for instance, if you pass $150 million package deal or $135 million package deal in Congress, then corporations get paid out the money, and then here comes the politicians hurrying up to buy stocks where they know where the money is going to go in as far as when they disperse the money in these corporations. See, and this is what we're talking about in politicians. This is how they always stay ahead of average persons. And then when we do it, they want to throw the law book at us. See, this is what we've been talking about. The corruption going on, the greed. And I told you, I'm not sure. I have to investigate this. But here's the thing: it's not just 131 federal judges. There are other judges involved in this, and I'm pretty sure Thrash, when he did the data breach for Equifax, like I said earlier, he had a conflict of interest there because he and Roy Barnes were longtime friends before Barnes even became governor of Georgia. That's a conflict of interest. Even in the sense of, you might say, oh, it's not a conflict of interest. The law also says that it appears to be a conflict of interest and that you shouldn't rule on your own conflict of interest situation in which Judge Thrash had done. If somebody is saying back in 2005 that you have a conflict of interest because of your bias or your disabilities or you don't like pro se plaintiffs, it appears that if you have 5 or 6 people who are saying that who are pro se plaintiff and they said, Judge Thrash, it appears that you are biased or you could be biased or have a disability according to federal law, and you still presided by those cases. If everybody is saying that, then that means that basically it means that it appears based upon the history. See, he should have not even reside over the Equifax um, data breach, because it appears that he had a conflict of interest by appointing the law firm that Roy Barnes has, that is now one of the owners or even the managing partners of. That's a conflict of interest. So the whole entire settlement from Equifax should be wiped out. And this is something that the objectors are not saying in a database. Now, keep in mind, nobody who really basically got who was damaged, which is individual people, by the way, and not these attorneys who are making millions of dollars from the data breach. They're giving this money to attorneys, not the actual victims of the data breach. You see, it goes on to say here that no, I'm sorry, I'm not reading no more articles. I want to talk about let's let's continue with the Equifax data breach. The Equifax data breach was that Equifax revealed millions of people data. And what happened is that they may have shown social security numbers, stuff like that. People have basically set businesses inside people's name by using their information. And so basically to settle that, they took it to court here, federal court here, and they settled on it. And here's Thrash appointing only 6 or 7 attorneys, law firms here in Georgia, where other law firms also reach deals in other states throughout the country. But the only people who are getting the money is attorneys. You understand? They're not the one who who basically who was the victims of this data breach. The attorneys, why are they getting the money? This is supposed to be handled in state court where the individuals as a class action basically receive the money and that the court cost goes to the attorneys along with their fees, not them getting millions of dollars from a data breach to which they're not the victims of. But see, Thrash presided over that case. And one of the problems with him is that he is one biased son of a bitch. This man from 2005 have been engaging in or presiding over cases where it appears to be a conflict of interest, which is a violation of the law. It appears, like I said earlier, that it's a violation of the law for Thrash to basically to reside up on as the judge in the Equifax data breach case because it appears that he has a conflict of interest with Roy Barnes, who is the attorney, his friend, and they've been knowing each other for years. See, what a lot of these judges do is that they'll have what they'll do is they'll have family members or they'll have people that is in other countries, and they'll send like a lot of this money to those folks, and it goes into their accounts, and then they'll pay them to stay quiet so that the breaches would so that nobody would see their little game plan and their little corruption of the law. You see. But I wanted to talk about this because these 131 federal judges should be fired. The Congress should have impeached them. And even if you have what they claiming that they're going to have a a hearing on what happened, they're not going to do anything. They're just going to set up more legislation because what you're doing is you're getting rid of almost all white men. And this country does not do that. Okay? Because they only pick and choose who they're going to go after when violating the law. Okay? So I wanted to just talk about this. This is a gross negligence. This is egregious. And all of these cases, um, basically should be petitioned for a new trial. And even in Georgia, where you have now Judge Batten, he basically is under fire. He should step down, and he's a appointee of Thomas Thrash. And see, Judge Batten is supposed to be conservative, and Thrash is supposed to be liberal. Thrash was appointed by William Bill Clinton, who claims to be the first black president before everybody saw Obama come in the picture. But hey, we don't know. But Judge Batten is trying now to make up a lot of excuses. But what he needs to be doing, and this is the reason why he should step down, Judge Batten. Judge Batten should step down because nothing he kept apologizing. But just like the Georgia federal court do, none of them asked and offered, could we basically retry these cases? He is not talking about that. When he was interviewed by the Wall Street Journal or told about his conflict of interest problems, he in a statement didn't even offer to look at the cases because there's so many. He was involved in so many cases, and then his excuse is, well, we put them all in mutual funds. So he knew that this was a conflict of interest. See, this is what we're talking about. There's no trust in the Georgia federal court system. And like I said, other judges out there, like Thrash, they also have a conflict of interest of being biased against pro se plaintiffs, which I think that the Wall Street Journal will do a good job that shows that. That should be the next hearing. But what do I know? I am just a regular talk show host. Join me. We're going to come back again and we're going to be talking about the R. Kelly situation. We're going to have new information about the Lives of the Man Act. We're going to go into it all. And that's going to be our new video. We're preparing it right now. We're staying on top of this because R. Kelly did get railroaded by the Homeland Security. And why do they? Wait a minute. The Homeland Security was not set up and designed to go after black celebrities. That's not what you was set up for, Homeland Security. And so we already know that the government railroaded them, and we already know that Sony played a very important role in it. We're going to be talking about all that coming up. Again, we're going to go live here on the Lawyer Henderson podcast show. Well, this is all my commentary. We might do a part two about this, about these corrupt federal judges. There's a lot of federal corrupt judges, and in my new book I'm coming out, we're going to talk about this. See, the Wall Street Journal beat me to the chase. We were going to talk about the corruptions and the conflict of interest that these judges have. See, on our show, we go after, we don't care how powerful you are. We basically go after everybody. We don't care if you're black, white, Asian, Puerto Rican. We go after everyone. Wherever there is injustice, that's why Screw 2 don't like us. Because Screw 2 knows that there is a no holds bar. Now, The Hill had done something. The news magazine, The Hill. I want to talk with them because I think they're becoming more open to a lot of things, even though I see still that conservative Fox News thing. If the Hill basically alone, see, this is the thing with the Wall Street Journal. The Wall Street Journal, you would expect them to basically report things of this nature. But it just took a long time for them to do it. I think the Hill, if they had those informations or if they were able to gather the information, I think they would have did a better job in uncovering the other judges who participated in the scandal. And I think, and this is a scandal, by the way, because they should not be ignorant to the law. They should have known it. And these improprieties is what we're talking about. And as far as the chief judge, they should really know better. When they take that oath of office, you should never ever have any kind of improprieties. And that's what we're talking about with Judge Batten. He should have known better. And so yes, this is what we're going to be talking about, probably in another podcast. I want to do a part two of this. I want to make sure that the Wall Street Journal's report not only is basically expanded, if you will, and what I mean by expanded, I want people to start understanding. Judge Joe Brown said something very interesting. I was listening to him the other day, and Judge Joe Brown said, about certain things about the federal court system, and so did, especially when he talked about the Cosby Law. So, what we'll do is that we will continue to follow up on this case. I think it's very important to follow up on what happened with these 131 judges. Will they be impeached by Congress? Now, you know that they're not going to do it. See, this is the reason why the people should be electing federal judges and not Congress. Because now they're going to try to hurry up and sweep this under the rug. And every time you go into their court, you're going to look at the bias already. You're going to see the bias already, even in the sense that they bring these people down. The federal court system is not designed specifically for black people. Understand? We get the raw end of the stick when we go into these federal courthouses. And over there in the Richard B. Russell building here in Georgia, all you have to do is Google him, and they'll tell you everything you need to know about Georgia federal court system. How am I supposed to go into the federal court to get justice, and the Richard B. Russell, the all you monuments is hanging right there, and it's called Richard B. Russell. We can look at him real quick if you want to. Richard B. Russell. See, this is who we're supposed to go in there and get some justice from. We're supposed to be going. We're supposed to be getting. We're supposed to be getting justice in a federal court house that is named after Richard B. Russell. Let's you understand? Let's look at let's see. There he is right there. Richard B. Russell. See, we're supposed to get justice from a racist like him. You're supposed to go into the courthouse and get some type of justice. Okay? Now, they're going to always talk about, oh, what did Russell do? And all of the stuff he did and all the, yeah. You know, if you look at a lot of these politicians, a lot of them, if you go and look at their family tree, go back, and back. Not only have their family said some foul stuff, but you will basically see it goes back to as racist as hell. They said some foul stuff, back in the 1900s. They said some foul stuff. Understand? The Democrats back in the day, let's say, like I said, back in Reconstruction, they said some foul stuff. Understand? So, if you look at Richard B. Russell, I think you'll see a lot of problems. See, here's the thing about him and their talk about civil rights. Lyndon B. Johnson, you know, signed into law the 1964 Civil Rights, but still, yet Johnson was not about to do anything really that effectively helped black folks. Remember, before this 1964 Civil Rights Bill, we've already had a bill of civil rights. You understand? And I think one of the things that we get caught up in as black folks is that even if even if we basically even think about justice, then white people will hurry up and talk about the civil rights movement. That was Johnson's real thing. He basically got people who were going to participate in this benign and neglect policy in the future, got them to basically um, say you can use this when people bring up the hatred that was brought in during Reconstruction. Well, use the civil rights laws and say, hey, this is what we did for you black folks. See, again, they want to give us symbolic gestures. Okay? Now, here you have Russell with Lyndon Baines Johnson. Okay? So, what that's supposed to do is that's supposed to say, hey, um, I'm a liberal. But it goes on to say about what it says about Russell and Johnson is after the Democrats, after they hid their hatred against black folks back in the days, Malcolm called them the Dixiecrats. Remember, they were called the Dixiecrats or whatever. And then they hid their history, like I said, of what happened during Reconstruction. Was it Reconstruction? Where they start to tell black folks that this is a black white man's country and it should be ran by only white men and stuff. But Russell and Johnson was one of the key figures to basically try to get folks to say, "Oh yeah, we help you Negroes participate in the civil rights legislation." But hell, Johnson was friends of the man who was filibustering the civil rights legislation. You see what I'm saying? Then it goes on to say that Russell promoted his young protege Lyndon Johnson, who became the majority whip and later the majority leader. This was the beginning of Johnson's rise to power, and he would not have succeeded so quickly without Russell's favor. Russell's name was twice put forward for nomination as Democratic candidate for president, although not a former candidate in 1948 and not in attendance at that convention. He will receive 263 votes from 10 southern states that were looking for an alternative to Truman in his civil rights platform. Russell refused to join the Dixiecrats, who subsequently broke away from the party to form their own slate. In 1952, he announced his candidacy and went on to win the Florida primary. His agenda included a strong statement to local and state rights against growing federal centralization. At the convention, he received a high 294 votes from 23 states and lost the third ballot to is it Adela Stevenson? Adela Stevenson. Okay, but but let's talk about this for a minute about this Richard B. Russell, because I had a friend who did some study on Richard B. Russell. He was very racist too. So him and Johnson, both of them was racist. Damn. And what the Democrats try to do, just like when they were talking about what's his name, the president, what's his name, Biden, they basically found out in geology that he owned slaves. So Richard B. Russell is one of these racists who sided with the Democrats, and they try to pretend like they are, was advocates of civil rights. They was trying to pretend like they basically were liking black folks, that they were wanting to be a part of Dr. King and the struggle for civil rights. A lot of these people, like I said, on these names, it's just now into recent in Decatur, they had taken down a monument of a racist dude. See, what you have to understand is that a lot of these politicians are aligned themselves with these racist people in the past. Richard B. Russell, Jennifer, what's his name? Bedford. There was a politician down in Selma who praised him. He got in trouble. A lot of your politicians praise, especially your white politicians, they praise these presidents or politicians in the past that has bias and racism towards black folks. And that's what I'm getting at as far as Richard B. Russell. He was no champion of real civil rights, this Richard B. Russell, by the way. But see, and it shows every time you go into the Georgia federal courthouse, it shows you that these folks play games with black folks. They're continuing their benign neglect that it was set up way back during Reconstruction, where they said that they chased all the black folks out of town, and they told everybody else, "Hey, this is a white man's country." And this was at the time where Republicans and Democrats, they were working together. They was trying to get everybody to work to one accord, have businesses doing business with each other. And here come the Democrats at that time, pretending like they were liberal, but their hatred, though, no, not pretending like they were liberal. They were really showing their real colors when they told these black folks to get out of town by sundown. Okay. So Richard B. Russell and their family, they were all a part of it as well. It really shows you that when we elected, like Joe Biden, for instance, we're continuing to see the hatred that white politicians have for black folks. And then every time they're called out, like Joe Biden is called out for it, they'll say, "I'm the only one who has done more for black folks than anybody you know." You remember he made that statement? Same statement that I believe that Lyndon Baines Johnson had said. And you still look at black folks, conditions. They're bringing other people over here to undermine us. Family, they have already got one, I think it was two Afghans who just got over here to the country. They've already been arrested for some stuff. Folks, these people are bringing them over here because they're identifying as white. And so, therefore, there is no justice in the federal judiciary at all because the judges were getting away with all this stuff because they didn't think that nobody would have access to their records. It takes a long time, yes, to get their financial disclosures. It does take a long time. That's how they can rule on a case for years, and you wouldn't know a conflict of interest. And here they come talking about, oh, I'm shocked, I'm mortified. I'm this and I'm that. You know what I'm saying? I didn't know that the law says that. No, ignorance to the law is no excuse. Ignorance to the law is no excuse. But back to my point about Richard B. Russell. 1897 is when he was born. He was born into a family that owned slaves as well. And let me tell you that he basically a lot of his stuff, a lot of the history of Richard B. Russell was covered up, by the way. Okay, a lot of the history. And so if you fast forward as a black person, as a plaintiff, I'm going into a federal courthouse and looking at Richard B. Russell, and I'm like, wait a minute, am I coming in here to get some kind of justice? Yeah, I think not. And as Dr. Claude Anderson taught us, is that the Supreme Court has never ever done anything for black folks. They've never ruled in favor of nothing. So this is what we're talking about in the judiciary. It is very much for white folks. Like I said, the police, they're about protecting white people's property. That's the reason why they were basically, put in office. Established for it. You see. And so we just wanted to go over all of this. But join me, family, when we talk more about R. Kelly's case that's coming up on the Lawyer Henderson podcast show. I see